Do you think I've ever believed when anybody has ever told me they use mouthwash?
No, I don't know. I thought the same thing.
No. All right.
Judge.
So
I'm fine with it. Okay.
Ms. Clough, you're going to come in today. You're going to meet with Mr.
That's
Coast.
fine.
You're going to drug,
Okay.
listen to me. You're going to do whatever, you're going to drug test today. You're going to sign any waivers for Mr. Coast. I'm going to amend your bond conditions. So
Judge, may I respond to that first?
Yes.
All right. So Ms. Clough is in a family recovery court. It sounds like the court is up to speed as to that. I don't know if adding additional bond conditions in this case. And I would ask the court to consider holding off on that, because if she gets into a rehab facility in Traverse City, then I think that this will all be taken care of. So I'd ask the court to hold off on the additional bond conditions. Sounds like she's got enough on her plate as it is. And I'm not suggesting she should be free to test. It sounds like she is testing, just in a different venue.
She is, well, she's not testing. She's failing to test. She's also testing positive. If she's in a family court, those same restrictions would be in place, not to use any illegal controlled substances or alcohol. So I'm going to add those terms. Obviously, Miss, I want you to go to rehab. So, but you look like, you know, so Mr. Coast will need you to see him today to sign those waivers. You need to enter and complete it. If you leave, that's another violation. So I will amend the bond conditions. And Ms. Clough, if you don't appear today, understand I will be issuing a bench warrant for you. All right.
That's okay. Yeah, that's fine. I agree with it.
All right. I will set this over then for pre-trial on May 28th at 8:30 in the morning. And Mr. Malaro will do the stipend order to adjourn. And good luck to you, ma'am.
Thank you. I appreciate it.
Judge, can I get a quick breakout with her?
Yep. Ms. Clough, I'm going to put you in a breakout room with Mr. Coast. And once you're done speaking to him, you are free to go. Let me see here. There, Coast. There you go. All right. You're going to get an invitation to join. Go ahead and join. All right. I have Mr. Raymer. Okay. This is in the matter of the people of the state of Michigan versus Shane Raymer, file number 23-21665 FH. Mr. Malaro represents Mr. Raymer, and I have Alexander Bayonetto appearing on behalf of the people.
Your Honor, Mr. Sears is actually, I apologize, I didn't mean to cut you off. Mr. Sears is actually on his way up to your courtroom right now to argue that.
Mr. Fry, did you have something else? We have Chad Marvin.
Yeah, sure.
I'm sorry.
Okay. Judge, if I may, on Mr. Raymer.
Well, I got to wait for the prosecutor.
Well, there is a prosecutor there, so I'm not. He's scheduled for 10 o'clock. I would like to be in your courtroom myself to argue the motion. So if we could just put this off till 10, I would appreciate it.
Okay. Mr. Raymer, I'll bring you back at 10 o'clock. All right.
Yes, Your Honor, that sounds fine.
All right.
Thank you, Judge.
Thank you.
Am I good to go?
Yep, you're good to go. Hi, you know what? I also need Chad Marvin. And Mr. Raymer, they want me to bring him back at 10.
So take Mr. Raymer back?
Yep, and I'll see him at 10, but I'm ready also for Chad Marvin.
Okay, ma'am, we'll get Mr. Marvin.
All right, thank you so much.
I am here.
All right, this is in the matter of the people of the state of Michigan versus Harold Joseph Morse. File number 20-19771 FH. Mr. Morse is present in the courtroom today. I have Rhonda Underwood appearing on behalf of Mr. Morse, and I have Ms. Holly here. This is the date and time set for probation violation hearing. Let me see. Looks like we have a violation of probation that he's failed to pay restitution in the amount of $11,019.72. Still owes $9,900. His discharge date is May 8th. So, Ms. Underwood, how would you like to proceed with Mr. Morse?
Your Honor, I talked to Mr. Morse a couple days ago. I wanted to know if he's had any luck getting money together.
Yeah, we did,
You guys speak up.
yeah, we're getting a loan, so for the $9,000.
When are you gonna have that loan?
In a couple days.
In a couple days.
Yeah.
So if I set this out to next week, you're saying you'll be able to pay the restitution off?
Yeah.
All right, so Mr. Morris believes he'll be able to pay the restitution by next Wednesday. Miss Underwood, I can adjourn this 1 week for him.
6344, you know who I am.
Well, it's policy and procedure.
Okay, I have MDOC here. We're in court, so thank you. I'm gonna set this over to May 14 at 8:30 in the morning. Miss Adams, could I get a notice of hearing from Mr. Morris because he's here in person?
Yes.
And Miss Underwood, you won't need to do the Stipman order to adjourn. So, Mr. Morris, have a seat on the bench behind you and we'll get that notice of hearing. Obviously, Miss Holly, if he pays the restitution in full and you want to terminate his probation, you can do that.
Okay.
Thank you. All right, so I have two gentlemen from MDOC. I have one gentleman standing. So, sir, what is your name?
My name is Bomarito.
Okay, Mr. Bomarito. And Miss Underwood, do you represent Mr. Bomarito?
I do.
Okay, so this is in the matter of the people of the state of Michigan versus Delshawn Bomarito, file number 25-22196FH. I have Rhonda Underwood appearing on behalf of Mr. Bomarito, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial in this matter. Miss Underwood, how would you like to proceed?
Your Honor, my apologies. I'm being asked to come back to Judge Oldsavers for a second right away. Can I?
That's fine. Go ahead.
Thank you. I will be right back.
Okay, thank you. All right, so Mr. Bomarito, I'm gonna change your screen name. Want to grab some files, you can. All right, and now I have a gentleman with MDOC who is seated. What is your name, sir?
Lee.
Say it again.
Lee.
David Lee. So, Mr. Lee, I am going to change your screen name. And then, Ms. Underwood went down to Judge Olsaver, so it'll just be a few minutes. Some people haven't showed up. Michael Dagger, Margosian, Chad May. Do you represent Chad May?
I do, Your Honor.
Do you know where Chad May is? So in the matter of the people of the state of Michigan versus Chad Everett May, file number 24-21847FH. I have Michael Dagger Margosian appearing on behalf of Mr. May. This is the date and time set for a pre-trial conference. I have Alexander Bayonetto appearing on behalf of the people. So Mr. May is not present in the courtroom. He is 4, 8, 9, 10, 11. Isn't that the one we got? Huh?
Yeah, this is,
Hold on 1 second. Okay. Mr. Bayonetto, what were you gonna say? Was this nolly prost?
that's what I was gonna say, Your Honor. I believe this case was nolly prost. It was ending in 847, correct?
Yes, sir.
Yep, I have a note from Mr. Went on May 5th that he filed the nolly with the court.
All right. Good job, Mr. Dagger Margosian.
Hey, Judge, it was Mr. May doing all of it.
All right.
But you could take credit for it. All right, so I believe Mr. Dagger Margosian, the last person you have in front of me is Castro Oliveras. I've got quite a few people lined up from the jail in front of him. Are you done in Judge Oldsavers?
No, I'll probably pop over there and come back then.
Okay, thank
Okay,
you.
Thank you.
All right, who do I have joining me from the jail?
Ted Marvin.
Chad Marvin?
Yeah.
All right, let me grab your file. Mr. Fry, that's you, right? So in the matter of the people of the state of Michigan versus Chad Thomas Marvin, file number 25-22239FH. I have Brian Fry appearing on behalf of Mr. Marvin, and I need a prosecutor, please. I guess it's going to be Alexander Bayonetto appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Fry, have you received a copy of the felony information prosecutor's request for discovery and witness list?
Yes, I have, Your Honor. At this time, we would waive the reading of the information and we would request that the court ensure a not guilty plea and schedule this case for a pretrial.
How far out would you like a pretrial?
A few weeks.
All right, well, I will enter a plea of not guilty on behalf of Mr. Marvin. And how about May 28th or June 4 at 8:30?
June 4, Your Honor.
All right, I will set a pretrial for June 4 at 8:30 in the morning because it was arraignment. My staff will prepare the notice of hearing. Mr. Marvin, you're also going to receive at the jail a advice of rights form. There's been a change in the law and we need those signed by defendants that you got a chance to review it and received it. So don't throw that away. All right.
Good.
Right. So I will see you back on that day. Thank you, Mr. Fry.
Thank you, Your Honor.
Okay.
Good
Yeah,
morning.
Mr. Murphy. All right. This is in the matter of the people of the state of Michigan versus Caleb Robert Daniels. We have three files, 23-21311FH, which is a probation violation. I'm sorry. We have 23-21356FH, which is also a probation violation. And then 24-22081FH, which is a new file set for pretrial along with a contempt of court. So I have Matthew Murphy appearing on behalf of Mr. Daniels and Isaac Sneed appearing on behalf of the people. Mr. Murphy, how would you like to proceed?
Your Honor, Mr. Daniels had a probable cause conference down in district court yesterday. Mr. Daniels, did you waive your exam yesterday on that file? So we wanted, I think that was something we talked about last time. We want to get that file up here and include it in a plea. I think that was a fleeing and eluding charge, which was he was arrested on spawning these cases. So, Your Honor, I think we're just going to ask to adjourn. I was hoping to have that processed down in district by today, get it up here, but I don't think they've gotten it up here yet because it was just yesterday. So if we could just adjourn for 1 week, maybe and get that file, get up for that file.
Mr. Daniels, did they tell you what day your arraignment circuit court is?
On the 14th, Your Honor.
All right, so what I'm gonna do is set all these over to May 14 at 8:30 in the morning. And Mr. Murphy will do the notice on the 2 violation of probations. If you could do it on the stipend order on the new file.
Yes, Your Honor.
And Mr. Daniels, we'll see you back on that day at 8:30 in the morning.
Okay, thank you, Your Honor.
Your Honor, could I have a brief breakout, Mr. Daniels, just for a minute?
Yeah.
Thank you.
Hold on 1 second. All right, Mr. Daniels. And Joe Zoom 2. All right, go ahead and join that breakout room.
Miss Underwood would get her shit together.
Miss Underwood does have her stuff together, but she goes back and forth between 2 courts. So she's not just in my court, so she will be here in a minute.
I apologize. I was speaking to myself.
Well, If you're loud enough, I can hear you. You're talking to me.
I didn't know it.
All right.
I thought this was a little less sensitive than it is.
No?
To be saw in person this last time, by the way.
Yeah.
Yes, and they said I had the right to be saw in person, but here I am behind the screen again.
So you do have a right to come in person, but you have to ask, and obviously you have a right to be present in person for jury trial and sentencing. But the default is usually Zoom for pre-trials, but if it becomes an issue or you request it, we can have you brought over in person.
Man.
Hey, Judge, do you have Bomarito's guidelines, or will I find that out today?
You're talking about your sentencing guidelines?
Yeah.
So, Mr. Bomarito, we don't typically do guidelines in advance in Lenawee County. I came from Wayne County and we always had the guidelines at the time of a pretrial, but that's not the standard procedure in Lenawee County. So your attorney may have done them, but I don't know.
All right.
All right, Ms. Smith, let's see, who's your attorney? You have Matt Murphy.
Yes, ma'am.
And I need to get Mr. Murphy back. So Miss Adams, can you send a message to Mr. Murphy?
I need a breakout room, too, Angelo, please. Judge Angelo.
Yep, I don't have Mr. Murphy yet, so we will send a message to him. Either Miss Adams or somebody. So give us just a minute. Mr. Murphy, all right, so I have Miss Smith. And let me call the case, and then she would like a breakout room with you. So in the matter of the people of the state of Michigan versus Jackie Mae Smith, file number 25-22206FH. I have Isaac Sneed appearing on behalf of the people and Matthew Murphy appearing on behalf of Miss Smith. This is date time, as I said, for pretrial. I'm going to open up a breakout room and give me 1 second. I'm going to put Mr. Murphy and Ms. Smith in that breakout room. All right, go ahead and join that breakout room.
We do have the plea agreement. I will sign it now. Can I sign this with your name to this, Ms. Smith, with your permission?
Yeah.
I'll get this over to the court.
All right, there's no sentencing agreement.
No sentencing agreement. We are going to ask for to address bond after the pleas enter, though, Your Honor.
Ms. Smith, you're not on probation in this circuit court anymore.
No, ma'am. I'm not on anything, ma'am.
All right. So, Mr. Sneed, is that a correct recitation of the plea?
Yes, thank you.
All right, Ms. Smith, you want to raise your right hand? Do Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So you have heard the statement of your attorney. Is it your intention to plead guilty to count one, larceny in a building, which carries a maximum penalty of up to 4 years in prison and or a $5,000 fine? Count two would be dismissed, as well as a habitual offender notice. So is it your intention to plead guilty to that count?
Yes, Your Honor.
All right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor.
And Ms. Smith, is that correct as far as you're aware?
Yes, Your Honor.
Okay. So Ms. Smith, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now. I'm sorry, to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined, okay, misconduct is defined but not limited to absconding, failure to appear for sentencing, violating terms or conditions of bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. I'm sorry. Do you understand that if your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right. So, Ms. Smith, how do you plead to the charge that on or about March 23rd of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense under count one, larceny in a building? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
No, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
Ms. Smith, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
And Ms. Adams, just to note, so Ms. Smith, we are going to be sending over to the jail an advice of rights form that reiterates basically all the rights that I've just given to you, and I'll need you to sign that and they'll send it back to us, okay?
Yes, Your Honor.
All right, so Ms. Smith, on March 23rd of 2025, we're in the city of Adrian in the county of Lenawee.
Yes.
All right, and did you steal money from a restaurant?
Yes, Your Honor.
What'd you do?
I put my hand in the tip jar and took $5 out.
Okay, and you didn't have permission to do that?
No, ma'am.
Were you an employee there?
No, ma'am.
All right, Mr. Sneed, are you satisfied?
Yes, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed
Yes, Your Honor.
and Mr. Murphy?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, or her rights, and she does have competent counsel. I'm going to set let's see, so I'm going to set this matter for sentencing on June 27 at 8:15. Mr. Murphy, you're available that day?
Yes, Your Honor.
All right, and
What day did you say, ma'am?
June 27 at 8:15 in the morning.
Thank you.
Before we proceed any further, Mr. Murphy, you wanted to address bond?
Yes, Your Honor. Ms. Smith, she did take responsibility today for, I mean, obviously it is a felony, but it is for taking, tips out of a tip jar. The guideline range, sentencing guidelines on this would be, 0 to 17 or 0 to 11 with an asterisk. So quite frankly, she's already been in jail now since late March, since when this happened. I would ask the court to consider a PR bond because obviously the time that she's served is something that I would say would be an appropriate sentence already. Now, Ms. Smith, I don't believe that she's a flight risk, as the court explained. It's even more now. So now that anything that she does or misbehaves between now and sentencing, it throws out everything that she's pled to, any agreement that she's had. And it's also exposed her to further charges. Ms. Smith is adamant that she would be willing to appear every day to the court or have a GPS tether. She understands that she has to abide by all the orders of the court and the bond conditions and appear for sentencing. So I would ask the court to consider a PR bond with whatever conditions the court thinks is appropriate for Ms. Smith.
Mr. Sneed?
Your Honor, the people would ask that a bond remain for Ms. Smith. This is likely a case where she's not fit for probation based upon her history, and a lengthy jail sentence will be recommended. Just like the court to consider that since 2022, Ms. Smith has had 26 cases just in Lenawee County, 7 of those felony cases. And since 2005, she's had over 31 cases in multiple jurisdictions, including Lenawee County. So Ms. Smith clearly, isn't probation material. She should serve time based upon anticipated recommendation for jail. Thank you.
All right, anything else, Mr. Murphy?
Nothing further, Your Honor.
All right, okay. So what I would say on the first part is that Ms. Smith has failed to appear in this court before. So I do feel that she potentially would abscond again. Secondly, yes, I've had so many cases with her in the last couple of years that I think more than 30 days in jail will probably be appropriate on this. And thirdly, Mr. Murphy, I don't think to dismiss the fact that she stole tips from servers. I worked as a server through high school, college, and law school. They rely on tips. So I think it's egregious whether or not it was from a tip jar or from the till. So I'm going to set this matter for sentencing on June 27 at 8:15 in the morning. Ms. Smith, do you wish to appear via Zoom or in person?
In person, please.
Okay, we'll set that for in person. Someone from MDOC is going to come over and meet with you. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide a copy to Mr. Murphy. Mr. Murphy will come and review that with you before the day of sentencing, and then we'll see you back on that day. Thank you.
Thanks.
Thank you, Ms. Smith.
All right, so let's see. Saw Caleb Daniels. Mr. Murphy, we saw Caleb Daniels. Saw Noah Lamley, I guess we need, right?
Yes, Your Honor.
Hello, Your Honor.
Hi, so I am ready for Noah Lamley. And yeah, let me see. Yep, Noah Lamley. I got 2 windows open.
Yes, ma'am. Believe we have actually, you should have Was Ms. Smith the only one you had right at that moment?
Yep, I have jail Zoom 2 open and one that says public defender.
Gotcha. That was the one our female, Ms. Smith, was just in, so I will close you down out of that one, and then I can get you two. You said you wanted Lamley.
I think just right now, Lamley.
Oh, okay.
I don't
perfect.
have any
Did you
other
still, 10
attorneys.
o'clock, want Mr. Rayner back?
Yeah.
Or are we waiting for your word on that one?
At 10, well, actually, before I see Mr. Raymer, I'm hoping to see, Daniel Sloan.
Okay.
And, Castro Oliveras. So we'll start with Lamley, then Sloan and Oliveras.
Yes, ma'am. Sounds good to me.
All right, sorry, thank you.
No worries. Thank you.
I don't know.
He's so polite. He's always polite.
There's been 80% change over since I left 4 years ago. Fine.
That's Colton. He is so friendly. He is so nice. They all are, but.
Of course, Joanna.
With that.
Joanna's.
I said, of course, Joanna. No.
Yeah, no, you know, and I've never seen him. I've never met him, but I remember talking to him downstairs. And he was always so nice and friendly.
I don't think Judge is on the bench.
Still in court. Still going? Still in court. All right.
You see Brenda's in front of Judge Wilson, he's not lying. All right, Mr. Lamley?
Yes, ma'am. Can you hear me?
Yeah, let me grab your file. All right, Mr. Murphy, in the matter of the people of the state of Michigan versus Noah Lamley, we have two files, 24-22063 FH and 25-22205 FH. So both are set for pretrial. There's contempt of court that came up from district court. On one of the files, I have Isaac Sneed appearing on behalf of the people and Matthew Murphy appearing on behalf of Mr. Lamley. So, Mr. Murphy, how would you like to proceed today?
Your Honor, we're going to ask to adjourn. We're still waiting for the forensic center to complete their criminal responsibility evaluation. It looked like there was some misunderstanding about the previous. There was an appointment on the 18th where Mr. Lamley was in custody. So I think they rescheduled that, but they haven't come back with that, and they've completed the evaluation, but they haven't come back. We haven't gotten anything back about their assessment. So we're just going to ask to adjourn. Hopefully we get that here soon.
So what I'm going to do is set it for June 4, but obviously once we receive that, we'll bring them in right away. So I'll set this for June 4 at 8:30 in the morning. And Mr. Murphy, can you do this step in order to adjourn?
Yes, Your Honor.
All right. And Mr. Lamley, hopefully that comes in sooner and we'll get you back in here quicker. All right.
Yes, ma'am.
All right. Thank you, Mr. Lamley.
Thank you, Mr. Lamley.
She's in front of him.
Yeah, and Sam's sitting in his courtroom right now.
Okay. All right. Miss Underwood is finishing up in front of Judge Olsaver right now. So she should be here in just a moment. I have Salvatore Milaro appearing on behalf of Mr. Raymer, and I have Nick Sears appearing on behalf of the people. This matter is pending from a jury trial conviction, and sentencing is scheduled less than a month away on June 5 of 2025 at 8:15 in the morning. Mr. Milaro, we are here today on your motion for bond reduction.
Correct, Your Honor. It pleases the court. Your Honor, I submitted my motion on April 28th, 6 days after Mr.
Raymer was remanded to the jail upon his conviction. I did go and meet with him. I believe that he is genuinely remorseful for his behavior that day. I did sit in on part of the trial. He readily admitted that he was intoxicated on that day. I believe that is the predicate for what happened. If he wasn't intoxicated, I don't think that he would be where we are today. Judge Hughes County today will have been in custody of 21 days. I did just receive his pre-sentence report. I did a brief review. I believe there's some of I would have some issues with some of the scoring. But that would be at another day. Even under his score now, it's 0 to 17. So that does not merit a prison sentence. Based on my conversation with Mr. Raymer, I believe that he is remorse genuine for this matter. I also, as I stated in my motion, that alcohol is, I think, the underlying factor. I believe if the court considers the criteria for release at post-conviction, I would argue to the court that clear and convincing evidence exists. This is not something that occurred with the public. It was with an interaction with the police. I believe the court can put in conditions for Mr. Raymer to maintain sobriety. I'm not aware of in the prosecutor's response that he missed the court date. If he did, our office was representing him at that time. I don't know if the court issued a warrant. These matters out of Missouri are a little concerning. I don't know if 2031 CR 05183 means that's a error. Is that a 2021, 2011 case? They all seem to be minor offenses. I'm not aware of there being a hold on jail for him there. I think Mr. Raymer would like an opportunity to show this court that he can be a productive member of society and that this is just a one-off here. And we'd ask the court to consider granting him a PR bond with appropriate conditions pending sentencing. Thank you.
Mr. Sears.
Your Honor, upon reviewing everything since post-trial with Mr. Raymer, our office is not too concerned with what you rule on whether to release him or not in the sentencing matter. We do believe every justice has been served with the trial and with the guilty verdict. At that point, to point out upon review of public court records from Missouri, I just wanted to make the court aware that it does appear that he has, it's technically 3 bench warrants for failure to appear, but 2 of those cases are the same date, time, same incident. So and then I believe the failure to appear was at the final pre-trial in December before the original trial was set for the 26th of December. Other than that, Your Honor, the people do not have too much more to add, and we'll leave the ultimate decision of this matter at the court's discretion.
All right. So thank you. In light of the fact that you've made the court aware that there is some dispute to guidelines, this matter is set for sentencing on June 5. I'm going to order that sentencing memos be provided to the court by both sides by May 30th. So obviously, Mr. Malaro, get that out so that he can file a response, so that way I can review it before the day of sentencing. Mr. Raymer, I appreciate what your attorney is saying in his request, but having sat through the jury trial and watched the body cam and being required to hear you call police officers a fucking cunt, at least I think I lost count at 30 times, and the dangerous situation that occurred that day, I do find that your behavior was egregious and that I do not have faith that you will not violate your bond conditions. So I am going to keep your bond or keep you remanded to the custody of the sheriff's department pending sentencing. Mr. Raymer, I will also say that you're not looking at a prison term. Okay, so don't worry about that. All right.
Yes,
and then I want you to think long and hard. I mean, this has got to stop. All right. Thank you, Mr. Raymer. We'll see you back on sentencing.
Would it be okay if I say something?
No, we're good. We'll see you back on sentencing.
Thank
Shane,
you,
I'll
Your
come talk to you.
Thank you.
Talk to you tomorrow.
All right, thank you, sir.
All right, thank you. Ms. Underwood, in the matter of the people of the state of Michigan versus Delshon Bomarito, file number 25-22196FH. Ms. Underwood represents Mr. Bomarito. Mr. Sneed represents the people. Ms. Underwood, how would you like to proceed today with Mr. Bomarito?
If I could just talk to him for half a second, Your Honor.
Yep,
You've
Mr.
spoken,
Bomarito,
but-
we have really good audio on today, so that's a good thing. So I'm going to assign Ms. Underwood and Mr. Bomarito to a breakout room. Mr. Bomarito, I think you'll go automatically and then I'll bring you back. But if you don't go automatically, someone might have to do it for you. Yep, he went automatically. All right, Mr. Lee, you'll be next. Thank you. All right, takes a couple seconds. All right, Ms. Underwood, how would you like to proceed with Mr. Bomarito?
Your Honor, the plea bargain offered to Mr. Bomarito is that Mr. Bomarito would plead guilty to count 1, assault of a prison employee with 1 supplement, Your Honor. Count 2, and the remaining supplements would be dismissed. We would also be asking at this time for a COBS to the low end of the guidelines, Your Honor.
All right, any, is that Mr. Sneed, one, a correct recitation of the plea and any position on any COBS to the low end of the guidelines? You're muted, sorry.
That is a correct recitation, and the people defer to the court's discretion regarding the sentence.
Okay, thank you. All right, that's fine, Ms. Underwood. So is your, and your client's gonna avail himself of that plea?
He will enter that plea today, Your Honor.
All right, so Mr. Bomarito, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, and Mr. Bomarito, Ms. Underwood, with 1 offense notice, that would make it a 7.5 years. Is that what that is?
I think it's.
With 1 sub, what would be the maximum penalty, Ms. Underwood?
I think it's 6, Your Honor.
Well, it's a 5-year felony.
Okay, then, yeah, I do think 7.5.
Okay.
Yeah.
Okay, all right, so Mr. Bomarito, you've heard the plea offer that was placed on the record today. Is it your intention today to plead guilty to count 1, assault of a prison employee with 1 habitual offender supplement, which would make the maximum penalty up to 7.5 years in prison and or a $2,500 fine, with a COBS agreement to a sentencing at the low end of the guidelines, whatever that might be. So is it your intention to plead guilty to that count today?
Yes, Your Honor.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the court will COBS to the low end of the guidelines. Ms. Underwood, is that correct?
That's correct.
Is that correct, Mr. Sneed?
Yes.
And Mr. Bomarito, is that correct as far as you're aware?
Yes.
All right, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Bomarito, do you understand? Let me go back there. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 3.10 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? So do you understand, Mr. Bomarito, if you commit another assault of a prison employee and are charged with offense, I will not be bound by that Cobb's agreement anymore. Do you understand that?
Okay.
They changed the law on that. So it used to be if something happened and the court wasn't going to honor a Cobb's or a Killebrew agreement, you would have the right to withdraw the plea. But the legislation has changed that now, and you wouldn't have the right to with absconding or failing to appear for sentencing, which isn't going to happen in your case, and violating conditions of bond or terms of sentencing. So basically, if you were to get another charge, that could be a violation of whether or not I Cobb's you to the low end of the guidelines. Do you understand that?
Yes, I do.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Bomarito?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Mr. Bomarito, has your attorney promised you what your sentence will be like in terms of guidelines or the minimum sentence?
No.
Okay, and it's your own choice to plead guilty?
Yes.
And you're satisfied with her as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, so Mr. Bomarito, on October 5 of 2024, were you at the Gus Harrison facility located in Lenawee County, Michigan?
Yes, I would.
All right, would you agree that that facility is located in Madison Township?
I believe it's located in Adrian.
Well, we call it Adrian, but it's actually located in Madison Township. Would you agree to that?
Yes.
Okay, and you were an inmate at that time at that facility?
Yes.
And you had been sentenced and you were serving a term there, correct? So you were lawfully imprisoned?
Yes, Your Honor.
All right, so at some point you came in contact with the Joshua Treyfry, who was an employee there. Was he a CO or was he a custodian? Like, what was his job there?
He was a CO.
Okay, and did you assault him in some way? Did you push him, pull him, kick him, punch him, spit on him? Tell me what you did.
I punched him, Your Honor.
You punched him? Okay. And you had no right to do that, correct?
No.
Yes.
No, Your Honor.
Okay, thank you. Okay. I swore you in, right, Mr. Bomarito?
Yes, you did.
Yeah, I did. Yeah, I did. I thought I did. Okay.
Sorry, Judge.
All right, Mr. Sneed, are you satisfied?
Thank you, Judge.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood
It has.
and Mr. Sneed?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's agreement to the low end of the guidelines, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. So Mr. Bomarito, you're going to get a packet. Someone's going to talk to you. They're going to prepare a pre-sentence report. Be truthful with them about your background, the events that occurred. They'll also look at your prior pre-sentence report. Ms. Underwood's really good about meeting with people within MDOC before sentencing, but sometimes MDOC won't let her schedule because they have other conflicts going on. So if she can't talk to you in advance, I will give her an opportunity to speak with you that morning. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Yes, I am, Your Honor. Mr. Bomarito is at Ionia, where they actually do let me schedule telephone conferences, Your Honor.
So Ms. Holly, he's at Ionia. All right, Mr. Bomarito, you do have a right to be present in person for sentencing, or you can appear via Zoom. What would be your preference?
I would appear via Zoom.
Okay, I promise you, we don't have as many cases on sentencing day, so it won't take as long. All right, so we will see you back via Zoom on that day for sentencing. And Mr. Bomarito, thank you for your patience this morning, and I'll see you back on that day. Thank you.
Can I ask you one question?
Sure.
Did you accept the Cobb's agreement or that's?
Yes, she did.
I'm gonna send you to the low end of the guidelines, whatever they are.
Okay. Thank you, Your Honor.
Thank you, Mr. Bomarito. You have a good day.
So.
Okay, Mr. Lee is next. So let me grab his file, put Mr. Bomarito's away. Okay, this is in the matter of the people of the state of Michigan versus David Edward Lee Jr., file number 25-22195 FH. I have Rhonda Underwood appearing on behalf of Mr. Lee. I have Isaac Sneed appearing on behalf of the people. This is date time set for looks like the first pretrial in this matter. So, Miss Underwood, how would you like to proceed with Mr. Lee today?
Can I speak to Mr. Lee for just a second, Your Honor?
So, Mr. Lee, I am going to pop you in a waiting room. We also have really good audio on Mr. Lee today. So, go ahead and join that breakout room. He went automatically. Mr. Sloan will be right with you. Miss Adams, I don't know how, but we're gonna have to send notice or advice rights forms to Mr. Lee and Mr. Bomarito to get that signed.
Are those the same ones used in district court?
No, they're the circuit court one.
They make a packet up, they take it to the jail, or they could just hand it to them.
Yeah. Yeah, so that would be great. So, Miss Adams, Deputy Lucy will talk to you because I think we can send a packet over to the jail. Good morning, Mr. Dagmar-Gosing.
Morning, Your Honor.
You have someone from MDOC. So are you done down in Judge O's?
I'm all done. I just have Mr. Oliveras here.
So we have Mr. Sloan, and so he'll be after.
Okay, thanks.
Ms. Underwood, how would you like to proceed with Mr. Lee?
Your Honor, the plea bargain offered to Mr. Lee is as charged, and the habitual 4 supplements will be dismissed. I would also be requesting a Cobb's to the low end of the guidelines in this matter, Your Honor.
So plead guilty as charged to count 1 in his habitual offender 4th notice dismissed. Mr. Sneed, 1, is that a correct recitation of the plea? And 2, do the people take any position on a Cobb's to the low end of the guidelines?
Your Honor, yes, it is correct, and we would defer to the court regarding the sentence.
All right, thank you. All right. So, Mr. Lee, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, and state your full name for the record?
David Edward Lee Jr.
Thank you. All right, you can put your hand down. And I apologize, I may ask you to speak up a little bit louder just because you're kind of soft-spoken to begin with. So, Mr. Lee, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison? The habitual offender notice will be dismissed and there's a Cobb's agreement to sentencing to the low end of the guidelines. So is it your intention to plead guilty to that today?
Yes.
All right. Are you satisfied with your attorney and the advice that she has given you?
Completely.
Good. Now, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the Cobb's agreement to the low end of the guidelines. Is that correct, Ms. Underwood?
It is, Your Honor.
Mr. Sneed?
Yes, Your Honor.
And Mr. Lee?
Absolutely.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Lee?
Completely.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Can you repeat that?
Yeah.
Is that a yes? Okay. You're kind of faint, and so we have to record this, and so I didn't pick that up. So, Mr. Lee, do you understand that if the plea is accepted and you engage in any misconduct as defined under MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. So if you were to commit a new criminal offense, the court wouldn't be bound to that Cobb's to the low end of the guidelines, and you wouldn't have a right to withdraw your plea because of that. Do you understand that?
Yes, I do. I've got one question though.
Yes, sir.
Not saying I'm gonna do it or anything. I'm not saying that at all, but is attempted suicide a crime now?
I would, okay, so one, Mr. Lee, don't do that. Okay, but that would not be a violation of this, no.
Okay.
But also, don't do that.
I won't, I won't. Trust me, I won't. I just wanted to know because sometimes I go through ups and downs and I don't take my medication sometimes and it just screws with my head.
Well, take your medication. It's, you know, you should take your meds, okay?
Of course I should.
Okay. What was the last thing?
Your Honor?
Huh?
You were explaining to him about that.
Okay.
I'm a little concerned. Mr. Lee's statement has made me concerned.
Why?
As to Mr. Lee?
Yeah.
I very much understand you want to get this over with today.
Yes, I do.
Much did. However, I'm concerned by your last statement that maybe we need to have you checked out by the doctors.
No, because I go through the doctor's shit all the time. I talk to the
So,
doctor.
Mr. Lee, let me ask you a couple questions. Are you currently taking your medication?
Yes, I am. I just wanted to know for further reference, just in case I might go through one of those pitfalls.
Okay, so right now you feel that you are stable medically and mentally, correct?
Yes, completely.
But you're concerned that one day in the future, if you weren't compliant with your meds and you had suicidal ideations, that could be a violation.
Yeah, yes, that was my concern.
Ms. Underwood?
That's it.
Mr. Lee, do you understand what we are doing here today?
Yes, I do. I have complete and utter cognizance right now. I am completely lucid.
And you understand my job? You understand the judge's job?
I understand all y'all's job.
Okay,
Prosecutor,
okay.
I'm stupid.
Chief,
I just,
thank you,
I,
Mr.
I,
Lee. Miss Underwood just has to make sure, okay?
I had a concern with how my moods are sometimes.
Okay. Well, and you should always voice concerns and questions if you have them, okay?
Yes,
Your Honor,
please don't know how I am.
I think that Mr. Lee does not demonstrate incompetence to me today.
Okay.
He demonstrates
Be confident.
perhaps
I'm completely
mental-
Oh,
confident.
we're good. Everybody, we're good. We're good. Mr. Lee, we're all good. Miss Underwood, thank you. Miss Underwood just needed to make sure. So I appreciate that she took the time to do that. So Mr. Lee, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes,
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
yes, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you today, Mr. Lee?
No, I asked the only question that I had.
Excellent. All right, so Mr. Lee, how do you wish to plead to the charge that on or about October 4 of 2024 in Madison Township in the county of Lenawee at the Gus Harrison facility that you did commit the offense of assault of a prison employee? Guilty or not guilty?
Completely guilty.
All right. So has anyone made any threats or promises to you to induce you to plead guilty to this charge?
Absolutely not.
Do you understand that if I accept this plea, you will be giving up any and all claims that, okay, and your attorney hasn't promised you any particular sentence or estimated what your sentence will be, Mr. Lee, has she?
No.
Okay, and it's your own choice to plead guilty?
Yes, it is. It's mine. I want to do this as soon as possible.
Excellent. All right. So Mr. Lee, on October 4 of 2024, were you incarcerated at the Gus Harrison facility?
Yes, I was.
Say that again for me.
Yes, I was. I came in contact with an officer, Tenniswood, and we.
Oh, hold on, Mr. Lee, you gotta only answer my question as we go, because I gotta make sure I get the elements. So on October 4 of 24, yes, you were incarcerated at Gus Harrison facility.
Yes.
Okay, and you were incarcerated there due to being sentenced on a crime, so you were lawfully incarcerated at that time, correct?
Yes, I was.
And would you agree that the Gus Harrison facility is in Madison Township in the county of Lenawee?
Yes, it is.
All right, now you mentioned Brian Tenniswood. He was an employee there. Was he a correction officer? What did he do there?
The correctional officer.
Okay, and at some point you assaulted him. So did you push him, punch him, kick him, spit on him? What did you do?
I elbowed him in his chin. No, in his cheek.
You say that again. You elbowed him. Where did you elbow him?
In his cheek.
In his cheek. Okay. All right. And you knew he was an employee of the Gus Harrison facility, correct?
Yep.
All right. Mr. Sneed, are you satisfied?
Yes, thank you, Your Honor.
Has court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I am going to refer this matter to the probation department for a pre-sentence agreement or a pre-sentence investigation. This court has made no agreement other than a COBS to the low end of the guidelines regarding any other possibility of a plea or possible sentence. in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Your Honor, the only thing I would say is it's shaping up that I'm having a lot of sentencing that day, both here and down the hall. Can we go a
Ms.
week
Adams,
later?
can I move that out one more week, please? Or to the next available sentencing date?
Yeah, we'll see. It would be Friday, July 18th.
All right, so Mr. Lee, I'm going to set this for sentencing on July 18 at 8:15 in the morning. Where are you currently incarcerated?
He's in Ionia, Your Honor.
I asked him, what'd you say, Mr. Lee?
Ionia Correctional.
Excellent. All right, Mr. Lee, you do have the right to be present in person. Do you want to appear via Zoom or in person? I promise you won't wait as long on a sentencing day. We have less cases that day, so we're able to get you in and out. But do you want to appear in person or via Zoom?
I'll deal with the Zoom.
Okay, so I'll mark that down for via Zoom. Mr. Lee, someone's gonna reach out to you and do a pre-sentence report. Be truthful with them about your background, the events that occurred, and then we will see you back via Zoom on that day. Miss Underwood is really good and Ionia is really good about letting her talk to you in advance. So she will review that pre-sentence report with you. If for some reason, like maybe they're on lockdown or something's going on and she can't meet with you, I will give her a chance to speak with you that morning. So I will see you back via Zoom. What, Mr. Lee?
I have a question.
Okay.
I have a question. Is it necessary that I go through the pre-sentence investigations process?
We're required by law to do that. I mean, you don't have to take part in it, but usually it's just you filling out a packet. So they'll look at your prior. Huh?
I'm not gonna fill the packet out.
Well, that's your choice, sir. So, Mr. Lee, we're also going to mail to you an advice of rights form that goes through the rights that I gave you today, and they'll have you sign that, and that'll get sent back to us, okay?
Okay.
All right, Mr. Lee, thank you for your patience today. You have a good day.
They were very taxed.
I know. All right, have a good day, sir.
You too.
All right, Mr. Sloan, in the matter of the people of the state of Michigan versus Daniel Robert Sloan, we have two files, 24-22044FH and 24-21690FH. I have Rhonda Underwood appearing on behalf of Mr. Sloan. I don't even know what you're here for. Hold on, let me back up a little bit, find you. This is the date and time set for pretrial on a probation violation on both of these files. I have Rhonda Underwood appearing on behalf of Mr. Sloan. Miss Underwood, how would you like to proceed with Mr. Sloan today?
Could I speak with Mr. Sloan for just a second, Your Honor?
Yes. So, I'm going to open up a breakout room and I'm going to put Zoom 2 and Miss Underwood into that breakout room. Very good. All right. So, Mr. Oliveras, good morning.
Good morning, Your Honor.
All right. This is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891FH and 24-21892FC. I have Michael Dagger Margosian appearing on behalf of Mr. Oliveras, and I have Dave McCready appearing on behalf of the people. This is the date and time set for pretrial. So, Mr. Dagger Margosian, how would you like to proceed with Mr. Oliveras today? Looks like we have a jury trial scheduled for May 14 at 10:30 a.m.
Judge, it's a bench trial. We had adjourned this case for us to get the preliminary exam transcript. We do have that transcript now, so we're ready to proceed next week.
Okay, so we are ready to proceed to trial. Anything we need to address today, Mr. Dagger Margosian?
Not from defense, Your Honor.
Mr. McCready?
People are all set.
All right, so Mr. Oliveris, I'll see you back on that day for a bench trial. Thank you.
Can I get a breakout room, lawyer, please?
Do you have time, Mr. Dagmar Roseanne?
Of course.
Okay, all right, I am going to open up a breakout room, jail Zoom 3. And Mr. Dagmar goes in. There you go. Go ahead and join that breakout room. All right, Mr. Byers, good morning.
Good morning.
This is in the matter of the people of the state of Michigan versus me, Jonathan Byers. Mr. Byers, I do have a request and summons for probation violation that was filed by the District Court Probation Department, which alleges that on I'm sorry, this is file number 23-21531FH. So, Mr. Byers, the allegation is that the Michigan State Police called the probation department and reported that you had submitted a PBT result of 0.051. You have probation terms for no alcohol, and the probation department advised they could lodge on a probation violation. And bond was set in the amount of $5,100, which is what I'm assuming is left owed maybe on that file. So, Mr. Byers, you do have a right to have an attorney represent you on this and all subsequent case hearings. Would you like an attorney appointed to represent you?
No, thank you.
Okay, so hold on 1 second. I'm with your probation terms, so hold on, it takes me a minute to find them.
I actually had court on it's either the 13th or 15th with you to just wrap up my probation. I paid off all my fines. I paid off the remaining $1,066. So really all I had to do was just show up and be off probation, but then I had this happen. But I plan on just pleading guilty to it.
Hold on. Don't say anything yet. Hold on 1 second. I gotta figure out, force and safety.
There's a recommendation on the back of that, Judge. I don't know if you've seen.
Reach the voicemail, Mike McCarron.
Mr. Byers, you know you have a right to an attorney. Are you waiving your right to a court-appointed counsel?
Yes, ma'am.
All right, Mr. Byers, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Mr. Byers, you understand that technically you're on probation for MDOT less than 200. So if you plead guilty or found guilty, I could give you up to 93 days in jail. Do you understand that?
Yes, ma'am.
I do have notes that you have paid everything in full. So, Mr. Byers, at this time, I'm going to dismiss the violation of probation. I'll give credit for time served. I'm revoking your probation. All right.
Okay, thank you.
Mr. Byers, stop doing stupid stuff and make better choices. All right.
Yes, ma'am, absolutely.
All right. Thank you.
Do I still need to appear on the 16th? Because I had court with you on the 16th already. It was pretty much
No,
just
you paid everything off according to the probation department, so we're all set. All right.
All right.
All right.
Thank you very much.
Thank you.
Bye.
So
am I like good to go today, or do I gotta have to stay in
yeah,
jail?
you're done. You're done with me unless you got new charges. I don't know, but my case, I'm done.
No, absolutely not. Okay, all right, thank you.
All right. Thank you. All right, so we're back with Mr. Sloan, Miss Underwood. How do you wish to proceed with Mr. Sloan? Do you waive the reading of the felony information? Or wait, no, it's probation violation. Never mind. So how do you wish to proceed with Mr. Sloan?
Mr. Sloan is going to plead guilty to this violation, Your Honor.
Right, Mr. Sloan, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Sloan, you've heard your attorney. Is it your intention to plead guilty to these violation of probations?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, ma'am.
Okay, trying to get to the violation of probation. Okay, so the allegation against you on both of these files is that you violated your articles of probation and that you failed to report to the Lenawee County Probation Department the following Tuesday upon your release from jail, and then you failed to report any time thereafter. Do you understand those are the violations against you?
Yes, ma'am.
On file number 24-22044FH, if you plead guilty or found guilty, the maximum penalty for larceny in a building could be up to 4 years in prison. Do you understand that?
Yes, ma'am.
And then on file number 24-21690FH, you're on probation for possession of methamphetamine. So the maximum penalty for that offense could be up to 10 years in prison. Do you understand that?
Yes, ma'am.
All right, now you do have a right, let me get back there. Sure, yep. Okay, so do you understand that you do have a right to have a trial on this matter and to contest the violation of probation charge?
Yes, ma'am.
Okay. You have a right to have that throughout the trial you would be presumed innocent until your guilt is proven by a preponderance of the evidence. You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you could ask them yourself, and to have me order any witnesses you might have to appear at the trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify? Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty, you will be giving up your right to a trial, as I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand all of that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Sloan, on both of these files, you were sentenced, and one of the terms is that you were to report to the probation department the following Tuesday after your release from the Lenawee County Jail. Is that correct?
Yes, ma'am.
And did you report to the probation department on that day?
No, ma'am.
Did you report any time after that?
No, ma'am.
Did you call them?
No, ma'am.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this matter for sentencing on May 15 at 8:30 in the morning. Is that day acceptable to you, Ms. Underwood?
It is, Your Honor.
All right, so Mr. Sloan, someone will be come over and meet with you, and they'll prepare a pre-sentence report. We'll provide that to Ms. Underwood. She's really good about reviewing that in advance, but if she's not able to, I'll give her a breakout room to speak with you. Do you want to appear via Zoom or in person?
Via Zoom.
Okay, so that'll be via Zoom. All right, thank you, Mr. Sloan. You have a good day.
You as well, ma'am. Thank you.
All right, thank you. All right, so Miss Ladd, is that you?
Yes, ma'am.
All right, let me grab your file. Looks like Mr. Dagger Margosian's still talking. Maybe, oh, okay, so this is in the matter of the people of the state of Michigan versus Samantha Diane Ladd. We have two files, 22-20962FH and 23-21239FH. Ms. Ladd, we are here on a request and warrant for probation violation, which alleges on each file multiple violations. One, that on April 17th of 2025, you were in possession of methamphetamine when you were positive for methamphetamine and marijuana. The second allegation is that on or about April 17th, you were tested positive for okay, so I have one, you tested positive on April 17 for methamphetamine and marijuana, and on April 24th, you tested positive for marijuana. And then on April 18th, you failed to notify the probation department that you changed your address. The next allegation is you have not been employed since being fired from McDonald's on or about January 15 of 2000 and, is that 21, Ms. Walsh?
23. 20, should be 25. 24. 25.
25, so I'll make that change. You can amend that. And then the next allegation is that you have not made any payments towards your court costs or supervision fees. Next allegation is that you have not engaged, hold on, Ms. Ladd, I'm talking. You have not been engaged in services to obtain your GED or high school diploma since May of 24. And then on April 18th of 25, again, another allegation that you're in contact with Joseph Garcia when he violated his bond conditions for domestic violence. So those are all the allegations against you. Now, on file number 22-20962FH, if you were to plead guilty or be found guilty of these offenses, you are facing a maximum penalty. Miss Walsh doesn't put the max penalties down for me. So let me see, this is 22. So possession of cocaine, the maximum penalty is up to 4 years in prison. What's the max penalty on use of methamphetamine? Is that a 1 year? I don't have the file, Ms. Walsh, I apologize.
What docket? What docket? I'm sorry.
On 22-20962FH shows count 2 as controlled substance. Is that use of cocaine or methamphetamine? That would be a 1 year misdemeanor, right?
Yes.
So Ms. Ladd, those are the maximum penalties on that file. And then on file number 23-21239FH, you're on probation for assault with a dangerous weapon, and the maximum penalty on that file could be up to 4 years in prison as well. So Ms. Ladd, you do have the right to have an attorney represent you on both of these files on the probation violation and any future hearings. Would you like an attorney appointed to represent you?
Yes, ma'am.
Now, Ms. Ladd, I know that you were taken into custody today. Are there any pending charges from that incident, Ms. Walsh, that you're aware of, or violations?
I'm not sure. She did run from our office, ran from office deputies. I'm not sure.
Okay, so Ms. Ladd, are you currently, and I need to know this truthfully because it'll impact what we do today. Are you under the influence of anything that would impair your ability to understand the proceedings here today?
No, ma'am.
All right, would you like an attorney appointed to represent you?
Yes, ma'am.
All right, Ms. Underwood, I am going to appoint you to represent Ms. Ladd. She's previously always had court-appointed counsel, so I do think she qualifies for court-appointed counsel. And I am going to open up that window and go ahead and join the breakout room. Okay, so that's that one. We have a couple more. All right, Ms. Innings and Mr. Biggs, it'll just be a minute. I apologize.
No problem, Your Honor.
Thank you, Judge.
Do you guys want a breakout room?
No, we already spoke, Your Honor, this morning prior to zooming in.
Okay, yeah, we had a lot of new arrests. It's a review, so will it take long?
No, I don't think so, Your Honor. Like,
Okay,
there's just
I'm
a
gonna
couple
stop.
things I have to say, and honestly, I don't think there's.
With all terms of probation concurrent in both files, all remaining counts and habitual supplements would be dismissed. And restitution in the amount of $6,000 will be paid by the defendant in file number 25-22246FH. Defendant shall undergo a substance abuse evaluation prior to sentencing to determine any treatment recommendations. And is there any other terms to this plea agreement, Mr. Sneed?
No, thank you, Your Honor.
Ms. Zilke?
No, Your Honor.
All right, the court will advise as of May 1, the law changed in the state of Michigan. So, Mr. Sinclair, previous to this, if the court, if you had violated bond conditions, the court would still be held to the plea agreement that was entered into, but due to changes in the law, if going forward, you violate your bond conditions, commit a new offense, or violate any of the terms, this court does not have to honor the plea agreement, and you do not have the right to withdraw your plea. Do you understand that, Mr. Sinclair?
Yes, Your Honor.
All right, we are also going to have your attorney provide to you an advice of rights form that your attorney is going to have you sign and return to her, okay?
Okay, thank you, Your Honor.
All right, I'm sorry, there were just some recent changes in the law. So are there any other terms to that, Mr. Sneed or Ms. Zilke?
No, Your Honor.
All right.
No, thank you.
Mr. Sinclair, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Now, are you satisfied with Ms. Zilke as your attorney and the advice that she has given you?
Yes, Your Honor.
Other than the agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the agreement. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Zilke?
Yes.
All right. And is that correct as far as you're aware, Mr. Sinclair?
Yes, Your Honor.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so we're going to start with file number 25-222 or 5FH. So, Mr. Sinclair, how do you wish to plead to the charge that on or about March 14 of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence, second offense? Guilty or not guilty?
Guilty, Your Honor.
All right, and then Mr. Sinclair, on file number 25-22246FH, how do you wish to plead to the charge that on or about June 7 of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense listed under count 4, larceny 200 to 1,000, guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to these 2 charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Sinclair?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Ms. Silky? No, Your Honor. All right. Has your attorney promised you any other particular sentence or estimate what your sentence will be other than the agreement that was placed on the record?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, Mr. Sinclair, we're going to start with file number 25-22245FH. So on March 14th of 2025, we're in the city of Adrian in the county of Lenawee.
Yes.
Okay. Were you in the company of a Sarah Ann Sinclair?
Yes, Your Honor.
Is that your wife?
That is my wife, yes.
Okay, so you committed some type of assault or assault and battery. So did you push her, pull her, pinch her, kick her, punch her? What did you do to her?
Pushed her, Your Honor.
You pushed her? Okay, and that was not consensual. She didn't give you permission to lay hands on her, correct?
Yes, Your Honor, correct.
All right. Now back on you recently, actually in January 24th of 2025, were convicted of domestic violence, second offense as well?
I believe it was the first offense, but yes, Your Honor.
Okay. So, and you pled guilty and were convicted of domestic violence in January of this year?
Yes, Your Honor.
Okay. Put a note in here. Okay. All right. Mr. Sneed, are you satisfied on that count?
I am. Thank you, Your Honor.
All right. So we're going to move on to file number 25-22246FH. So Mr. Sinclair, on June 7 of 2024, we in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
All right. And at that time, did you have, did you use the name of a May Reed Carpenter to obtain a credit card?
Yes, Your Honor.
All right. Did you have her permission to do that?
No, Your Honor.
All right. And did you receive that credit card?
Yes, Your Honor.
And then did you use that card to purchase items that equal the value of $6,000?
Yes, Your Honor.
Okay. And you had no permission to purchase those items?
That is correct, Your Honor.
All right. Mr. Sneed?
People are satisfied, Judge. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you.
And Ms. Silky? Yes, Your Honor. All right. So Ms. Silky also did waive the reading of the felony information for purposes of arraignment. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Sir, are you on West Maumee or Broad Street? What's your address? Not, I mean, just yes or no, Broad or West Maumee?
Broad Street.
Okay. All right. So, are you going to be able to do the vice rights, or you want us to mail it to them?
I should be able to do that.
Okay. All right. We'll need that by sentencing. Is that all right?
Yes.
All right. So I'm going to refer this matter to the probation department for a pre-sentence investigation. These are both misdemeanors, so it would be done by district court. So a week from tomorrow, I need you to report to district court probation between 8 and 10 a.m. And they'll give you instructions about how to go forward on the pre-sentence interview. When you meet with them, be truthful about your background, the events that occurred. And then I'm going to set sentencing for June 27 at 8:15 in the morning. Are you available June 27, Ms. Silky?
Yes, Your Honor.
All right, so sentencing will be June 27 at 8:15 in the morning. Mr. Sinclair, do you wish to appear in person or via Zoom?
Zoom would be better.
All right.
Just with my
And
work
again,
schedule.
Okay, that's fine, since your jail term is suspended. Mr. Sinclair, again, I remind you that due to changes in the law, if you violate your bond conditions or commit any new offenses, understand that I can not honor the plea agreement that was struck, okay?
Yes, Your Honor. Just to clarify as well, so Thursday, May 15th would be between 8 and 10 a.m. I need to report to probation?
Yeah, next Thursday is May 15th, yep.
Okay. Just trying to write all this down on my calendar here.
All right. Anything else, Ms. Zilke?
No, Your Honor, thank you.
Anything else, Mr. Sneed?
No, thank you.
All right, thank you all, and thank you, Ms. Zilke.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Sinclair. Okay. All right, we are back, Mr. Murphy, with Mr. Hodges. So, Mr. Murphy, how do you wish to proceed with Mr. Hodges?
Your Honor, I discussed the matter with Mr. Hodges. He's asking us to set a jury trial on the matter. We believe it would take one day of the court's time to set.
All right. So, Mr. Hodges is charged with one count of assaulting, resisting a police officer, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine. He does have a habitual offender fourth offense notice. So if he were to be convicted at trial, he would be facing up to 15 years in prison. So I am going to, I'm going to assume this is a one-day trial.
Yes, Your Honor, that's what we're asking for.
All right, Ms. Adams, I'm looking for a one-day jury trial. He's not in custody, so I understand that might be later in the summer. Unless you want to bring me the book and let me set trials, it's up to you.
We do have one scheduled July 15th, supposedly getting a plea this month on.
I'm sorry, we're getting feedback somehow. The gentleman from MDOC, I'm gonna pop you in the waiting room again. All right, Mr. Hodges, go ahead and mute your device because we're getting feedback, please.
Mute.
Yeah, go ahead and mute it. I'll do it. I did it. Okay. Miss Adams, what day?
July 15th, it's a Tuesday.
Who's that trial is there a primary trial with someone in custody?
He is she is an MDOC Shannon Foley. It's a one-day, have a plea scheduled for May 28th.
All right, July 15, you said then, Mr.
Yes.
Murphy?
That works for my schedule, Your Honor.
Mr. Sneed?
Yes, that works for the people. Thank you.
All right, so that'll be at 9 a.m. that is in person. I'm going to set a final pretrial for July 9, 25 at 8:30 in the morning. And I'm going to require that jury instructions and voir dire questions be provided to the court by July 2nd. And motion deadline will also be July 9, 25. Okay. All right. So I filled out a scheduling order and we will get a copy out to everybody. Mr. Hodges, make sure you stay in contact with Mr. Murphy so that you can prepare for trial. Make sure you let him know if your phone number changes or anything of that nature, okay?
Yes, ma'am.
All right, thank you. Your bond's continued.
Thank you, Mr. Hodges.
Okay, so, Mr. Morris, I do not have Rhonda yet. She goes next door first, so I know you're here and I'll keep track of it. All right. Okay.
Good morning, Your Honor.
Good morning. So I have 4 people that I'm ready for.
All righty, ma'am. Go ahead when you're ready.
Gary Bowerman,
Okay.
Sean Raymer.
Raymer, okay.
Yep. Caleb Daniels.
Mr. Daniels, got it.
And Jackie Smith.
Ms. Smith, got it.
And I think they let you know we won't be seeing Trent Berry today.
No, Mr. Barry.
Yep.
All righty, Your Honor. You will get them in that order.
All right. Thank you so much.
Absolutely.
All right, Walter Nelson, if you can, there you go. Can you hear me, Mr. Nelson?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Walter Douglas Nelson II, file number 25-22209FH. I have Ryan Montoya appearing on behalf of Mr. Nelson, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference. Mr. Montoya, how would you like to proceed?
Good morning, Your Honor. Thank you. One housekeeping matter. We are in receipt of an amended information dated April 14th of this year. We would waive any formal reading and stand mute with respect to that, Your Honor.
All right.
And as for the pretrial, the parties are requesting an adjournment for further law enforcement investigation that we believe will facilitate a resolution in this matter. I would defer to Mr. Sneed for how long we need. I would think it probably a couple months, maybe. I don't know.
All right. July 9th, is that all right with you, Mr. Sneed?
Yes, thank you.
All right, so I will set this for July 9 at 8:30 in the morning. And Mr. Montoya, if you could do the stip in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, please. Thank you, Mr.
All right.
Martin.
All right, Mr. Nelson, your bonds continued, and we'll see you back on July 9 at 8:30 in the morning.
Okay, thank you, Your Honor.
Thank you, Mr. Montoya.
Thank you, Your Honor.
Good to see you.
You too.
All right, let's see. Mr. Laura, I have Mr. McGowan.
Myers.
She just ran? Did they tackle her? Oh,
And
She
Lee
wasn't-
Myers is a new one that Mike's working on the board.
okay. I'm just gonna put those right here. Okay. I have a bunch of Winters, Miss Dumont. All right, Jeffrey McGowan, go ahead and unmute your device, Mr. McGowan.
Yes, Your Honor, can you hear me?
Yes, I can, thank you.
Yes,
So
ma'am.
this is in the matter of the people of the state of Michigan versus Jeffrey Steele McGowan, file number 25-22211FH. This is date and time set for pretrial. I have Salvatore Malaro appearing on behalf of Mr. McGowan, and I have Isaac Sneed appearing on behalf of the people. Mr. Malaro, how would you like to proceed today?
Your Honor, it has to adjourn the matter one time. We're working towards resolution. I'm hopeful that we could get the matter resolved by.
The objection, Mr. Sneed?
I have none. Thank you.
Great, I'm gonna set this over to July 9 at 8:30 in the morning. Mr. Malaro, you can do the stip in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, thank you.
Again,
you, Judge.
always, if a resolution is struck, I always appreciate if you guys bring them in on a day, not a Wednesday, just takes care of our docket load a little bit. So Mr. McGowan, your bond's continued and we'll see you back July 9 at 8:30 in the morning. Thank you.
Yes, Your Honor, thank you.
All right, I have two people have zoomed in on Winters. So both of you, if you could unmute your device and start your video so I can see which one is the one I'm actually looking for. All right.
Good morning, Your Honor.
Good morning. You're David Winters. Now there's a Jennifer Winters.
Right.
And who is she, Ms. Demont?
Your Honor, she's my client. They are co-defendants. Mr. Malero has Mr. Winters.
Oh, I'm sorry. Okay. Okay, so this is, I'm gonna start with Mr. Winters first. So in the matter of the people of the state of Michigan versus David Winters, file number 25-22200FH, I have Salvatore Malaro appearing on behalf of Mr. Winters. And I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, how would you like to proceed with Mr. Winters? I can't hear you. I'm so sorry, Mr. Malaro. Tap that mic or something.
How about, can you hear me now, Judge?
Yeah, your mic's activated now. Thank you.
Yeah. So, Judge, I'm going to ask to adjourn this briefly. I thought we'd have a plea agreement finalized, but I was out last week and I wasn't expecting that. And so I don't have that finalized, but I'm confident we'll get it resolved in short order. So that's the basis for my request.
Is June 4 okay?
Yes, June 4th is fine.
All right, so I will set this for pretrial on June 4 at 8:30 in the morning. If you could do the stip in order to adjourn, Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, thank you. Thank you, Mr. Winters. Your bond's continued. So in the matter of the people of the state of Michigan versus Jennifer Winters, file number 25-22201FH, I have Katerina Dumont appearing on behalf of Ms. Winters. Ms. Dumont, are you also asking for an adjournment to that day?
Your Honor, that's fine. I think if our case could follow Mr. Winters' case, at his sentencing, Ms. Winters' case is supposed to be dismissed based on the plea agreement.
All right, so Ms. Winters, I will set your pretrial for June 4 at 8:30 in the morning. And then Ms. Dumont, if you can prepare the pretrial notice. Mr. Sneed, can she sign your name with permission?
Yes, please. Thank you.
All right, very good. Thank you both. Stay in contact with your attorney and I wish you the best of luck. All right, thank you, Ms. Dumont.
Thank you.
So, let's see, got the jail. Miss Adams, if you could send a message to Mr. Fry that I have Michelle Harding. Thank you. All right, Mr. Bowerman, can you hear me?
Yes, Your Honor, can you hear me?
I can hear you. So
Good morning.
this is in the matter of people of the state of Michigan versus Gary Bowerman. We have, two files. We have file number 25-22242FH and 25-22243FH. I have Salvatore Malaro appearing on behalf of Mr. Bowerman and Isaac Sneed appearing on behalf of the people. This is a date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the felony information? I can't hear you. I'm so sorry. I think you and I should take both of our laptops and throw them out the back window. Because I have one in my office. The mic doesn't work either.
How about now?
Yep, that's better.
Great. All right, Your Honor, on the file ending in 242FH, we would waive reading of the information. If any defects as time and place of service of that information. Mr. Bowerman would stand mute as to count one in the habitual offender fourth notice. We would further acknowledge receipt of the witness list. As to the file ending in 243FH, we would further waive reading of that information, waive any defects in time and place of service of the information. Mr. Bowerman would stand mute as to the count one and the habitual offender fourth notice. We'd acknowledge receipt of the witness list. And we'd ask the court to enter not guilty pleas as to both cases and set the matter for pretrial.
How far out would you like a pretrial?
Judge, we're working on Mr. Bowerman entering rehab. I think I put a request in for him to be screened for recovery court. So I would leave it to the court's discretion how long we should have this set out.
Okay. Last time I sent him to rehab, he ran away. Okay. How about June 11 at 8:30 in the morning?
That's fine, Judge.
All right, so we will set a pretrial for June 11 at 8:30 in the morning. Mr. Bowerman, you're going to receive a notice at the jail as well as an advice of rights form. Keep that advice of rights form and we're going to need you to sign it and we'll have it sent back to us. That's in case you ever enter a plea. So, Mr. Bowerman, I will see you back shortly on June 11 at 8:30 in the morning. Thank you, Mr. Bowerman.
Your Honor, there ain't no way I can get a PR bond and go to rehab and do this while we're waiting for this matter. I promise you, Your Honor, I will complete it this time. And I know the sincerity of this and myself and the recovery.
I know, but the last two times you ditched me, even sent me messages from Florida. So no, I'm not releasing you on a PR bond today. Your attorney can file a motion and we'll screen you for recovery court, but you have a tendency to run. So I think you're a flight risk. So thank you, Mr. Bowerman. Nice try though.
Oh my God.
Okay, Mr. Fry, why don't you come up? All right, I have somebody on a Samsung device. I'm going to send you a request to unmute. If you can unmute and tell me your name, please.
Yes, it's Amy Clough.
Say it again.
Amy Clough.
Spell your last name.
Clough.
Okay, got it. I'm gonna write your, who's your attorney?
Malaro.
Okay. Mr. Malaro. Okay. So, Mr. Malaro, let's take her real quick. All right, this is in the matter of the people of the state of Michigan versus Amy Clough. File number 25-22154FH. I have Salvatore Malaro appearing on behalf of Ms. Clough, and I have Isaac Sneed appearing on behalf of the people. This is date and time set for pretrial. All All right, Mr. Malaro, just so you know, Ms. Clough was entered into the Family Treatment Court Program in Hillsdale. Ms. Clough is currently pregnant and testing positive for methamphetamine, THC, and alcohol. She tested positive for methamphetamine and THC on April 7 of 2025 and positive for THC and alcohol on April 16 of 25, and she has missed 6 consecutive tests in April. Ms. Clough, I'm going to need you to come to the courthouse today.
I'm currently getting around.
I can't hear you. Your audio is not working well. So kind of maybe move towards a window.
Okay. I have court in Hillsdale today as well, and then I leave for rehab.
Who's sending you to rehab?
Myself. I kind of just made the decision on my own to go. It's kind of very important. I want it. I need it. I'm struggling with a lot of things from domestic
So
violence.
what rehab program have you been admitted to?
I'm going to, it's addiction treatment. Addiction treatment in Traverse City.
What's the name of that?
I think it's
rehab
Addiction Treatment Association, I think it is.
Judge, she is in the family treatment court, and I did speak to her caseworker yesterday. She was in treatment, and she was missing counsel appointments with them. And it seems too that she's been bouncing between counties, that she's living in Lenawee County sometimes and partially in Hillsdale County, which is throwing off her aid for treatment. So
I have a counselor in Lenawee County at Catholic Charities that I've been seeing. I don't know if that she dropped me as since I'm going to rehab, that I guess she let me go until I come back from rehab.
Mr. Malaro?
Well, none of that sounds really very good, Judge, but if she's scheduled for this rehab in Traverse City, I would ask the court to consider perhaps adjourning this a week to verify that she has entered the program up there. I think the main goal here is to get her clean, sober, for both her and her child. That would be, I think, a prudent thing to do here.
Mr. Coast, are we able to get a waiver to verify whether she goes there tomorrow or not?
yeah, Judge, I'd like for her to actually come in today to where we could actually do that drug screen. I can have her sign a release form, and I can make contact with that treatment facility to coordinate that.
All right, so Ms. Clough, here's the deal. Obviously, a rehab is something that you need, but you're also pregnant. So if you don't go, I will make sure you're not using. So, Ms. Clough, I do need you to come here today to sign a waiver so that Mr. Coast can contact the treatment program. Do you understand?
You get
Ms. Clough, you're gonna have to move towards a window or somewhere. So you're kind of frozen. All right, Mr. She's dropped out. She'll probably drop back in. So let's hold on a minute. All right, Miss Harding, you have your attorney here. So in the matter of the people of the state of Michigan versus Michelle Lynn Harding, Miss Harding is present. You are Michelle H's Michelle Harding, right?
Right.
Okay, I just wanted to make sure. I have Brian Fry appearing on behalf of Miss Harding. Looks like I have Alexander Bandetto appearing on behalf of the people. Mr. Fry, how would you like to proceed today?
Yeah, sure. We would be asking for an adjournment today. My client is in the process of being screened for recovery court. My understanding is they're planning to screen her at the next meeting on the 15th. Assuming that it's ready and done by then, but we just asked for it to be adjourned out so we can know the results of that screening.
May 28th?
That'll work, Your Honor.
All right. So Ms. Harding, I will adjourn this out for a pretrial on May 28 at 8:30 in the morning. Mr. Fry, if you can do the step in order to adjourn, Mr. Sneed or Mr. Bandetto, can you sign your name with permission?
Yes, Your Honor, thank you.
Thank you, Your Honor.
Okay.
Thank you.
All right. Thank you, Ms. Harding. All right, Mr. Malauulu, she is not logged back on, so I'll pass her for a moment. If she doesn't get back on soon, I'm issuing a warrant. All right, okay. So what's your name?
Waiting for Jackie Smith.
Okay, all right. Quit watching TikToks in here. I heard the music, all right. If I can't watch TikTok in here, you can't watch TikTok in here. All right. Okay. All right, I have nobody. Nobody. Oh, wait, she might be back. Sam.
Imagine standing before a judge, knowing that one guilty plea could change the rest of your life forever. That was the reality for this defendant, who appeared in court charged with breaking and entering a building, a felony offense carrying serious consequences. But before accepting the plea, the judge refused to rush the process. She carefully explained every constitutional right the defendant was about to give up: the right to a trial, the right to confront witnesses, and the right to force the prosecution to prove the case beyond a reasonable doubt. The defendant confirmed that she understood everything and admitted she was pleading guilty because she had actually committed the crime. It was a calm courtroom, but everyone knew this decision would shape her future. What made the hearing especially interesting was that the plea agreement didn't include any sentencing recommendation. The prosecutor agreed to dismiss another charge of assault and battery, but the judge still had complete authority to decide what punishment would eventually be imposed. Instead of sentencing her immediately, the court ordered a pre-sentence investigation. That meant probation officers would interview the defendant, review her criminal history, employment, family background, and personal circumstances before giving the judge a recommendation. It was the court's way of making sure the sentence fit not only the crime, but also the individual standing before the bench. The judge reminded everyone that accepting a guilty plea doesn't automatically mean someone goes to prison the same day. Sometimes the court needs more information before making a life-changing decision.